joined the session in the morning and had a really nice lunch and lots of networking in between. So it is a pleasure to welcome you all to today's panel discussion on a topic that sits in the intersection of legal certainty, economic growth, and international cooperation. Just to say the topic again, what does the same seat for arbitration mean for the rule of law in attracting investment and increasing trade? We will also focus a bit in the context of Thailand. I am delighted to introduce you to the panelists. In no particular order, I'll start with my law professor from 2010, Assistant Professor Dr. Thidarat Silapat Hirosuk. Please give her a round of applause, please. Thank you. Ajahn Thidarat is a full-time professor at Chulalongkorn University Faculty of Law and currently serves as Director of the Center for Dispute Resolution. Ajahn Thidarat is involved in amendment and development of many key legislations in Thailand and also regularly sits as an arbitrator. Secondly, Mr. Ian Johnston. He was once an opposing counsel to me and now we're paneling together. So Ian is currently a partner at Walton Kearney's Bangkok office and has practiced in Bangkok, Singapore, and Hong Kong since 1999. Ian, everyone. Ian is qualified in England and Wales and Hong Kong and advises clients in the energy, construction, property, commercial, and hospitality sectors, as well as insurance. Ian is also on the panels of many arbitration institutions and has sat as arbitrator. Good to have you, Ian. Last and certainly not least, personally for me, this is the first time I have worked with our next panelists, but we've known each other for many years. Mr. Warathon Wongsawatil. Everyone. Mr. Warathon is the managing partner of Herbert Smith Freehill's famous Bangkok office. With over 20 years of experience, Kun Warathon has built a reputation for handling complex and high-profile commercial disputes. His practice covers high-court litigation, class action, and international arbitration. He also regularly sits as an arbitrator. Welcome you all to the panel, and thank you very much for being here. So first, I'll set the scene on what we are going to discuss today, and I will hand over to my panelists to share their experience and their views. So, as a global commerce becomes increasingly complex and cross-border, the importance of reliable, impartial, and enforceable dispute resolution mechanisms cannot be overstated. Arbitration has in fact emerged as a cornerstone of international trade and investments, offering parties a means and a forum for resolving dispute resolution. But the effectiveness of arbitration depends not only on the rules itself, but also the institutions, the parties, the mechanisms, the know-how, and knowledge that people bring to the dispute resolution scene. So it depends critically on the legal environment of the seat as well. As to the safe seat for arbitration, this is more than just a jurisdiction with modern laws. It is a place where the rule of law is respected, where court supports arbitral proceedings, and where awards are enforced predictably. For Thailand, this raises an important question. How do we position ourselves as a safe and attractive seat? What reforms or development that we can do to strengthen investors' confidence in Thailand as a safe seat of arbitration? And how does this contribute to the broader goals of economic development and regional integration? So today's panel, as you have hopefully grasped from my introduction of the panelists, will share experiences and knowledge. First, I would like to invite Ian to talk about how other widely accepted jurisdictions, in particular the UK, is trying to create a safe seat and what we can learn from them, and in fact samples of how Thailand can also attract foreign trades through arbitration. Thank you very much.
Thank you, Kunla. Thank you for the wonderful introduction as well. I think you'll find that there's a theme as the speakers kind of go through the slides we put together before we talk more generally. You could probably sum it up as the 3 C's: certainty, certainty, and certainty. That's what people are looking for in terms of places to invest, and the legal system and ADR has its part to play in that. And the question, I guess, that we're sort of intimating is, are we there yet in terms of Thailand having the 3 Cs? And whilst we'd say we're a long way there, I think we'll look at the fact that there are maybe some bits not quite there. In relation to that, I'm going to sort of do 2 things today. One is I'm just going to look at what the UK has done. So, an environment where I think it's probably correct to say it's sort of the second oldest arbitration sort of institute in the world with the LCIA, and how they have sort of perceived weaknesses in their arbitration offering in the UK and what they've done to try and improve on that. So we'll look at if the UK is doing these things, is that something we think that maybe Thailand should be doing? And let's look at what the UK has done in the UK Arbitration Act, have a look at those elements and consider whether or not something similar for Thailand would be a good idea. Then I'm going to look at the fact that as a panel we kind of thought that rather than, probably all of you have got experience of delegating work, and if you email 3 people and say, hey, can you do this please, then 3 people will be expecting someone else to do it. And on a government level it could be the same in terms of changes to arbitration. So we decided that we'd pick out a particular aspect of arbitration in Thailand and say, is this an area that could be improved? And I'm going to speak about the insurance arbitration here. Very much in terms of insurance, not reinsurance, but we'll look at that. So hopefully you'll see where we're going in terms of lessons for Thailand effectively. So these are the key reforms that the UK Arbitration Act has been bringing in, and see if this sounds familiar. Uncertainty around the seat of arbitration in the governing law, something that's an issue in Thailand, and it's been picked up by many people. And so what they've done in the UK Arbitration Act is they clarify the governing law of arbitration agreements, where it hasn't been specified by the parties. And essentially what they've said is they want the governing law to default to the law of the seat whenever it's unspecified. And by doing that, they've removed a lot of the ambiguity around that issue, and they've aligned themselves with what is very much the international standard and best practices. Now, as I said in the slide, this is providing confidence and predictability of outcomes. So there we are, certainty. There's the first time we're going to mention that word. This is very much something that Thailand, we would suggest, needs to follow suit on. How and when they do that is obviously very much the question is up in the air at the moment, but it is something that we perceive as being one of the main things they can do to bring some level of certainty that isn't there already. The second thing that I'm looking at in terms of the UK Arbitration Act is the codified duty of disclosure. Now, we've all been involved in arbitrations, we've all seen sort of various different disclosure processes in terms of how it works. In the UK now there's a statutory duty to disclose any circumstances that might raise doubts about impartiality. Now, obviously that can be a very broad spectrum of different things. In my own example, I always try to go beyond not just cases that you've been involved in or parties that you've represented, but even into the fact that you might know some people socially. But having a statutory duty to disclose potential conflicts makes sure somebody has to do that. And again, it provides problems with impartiality coming up at a later stage, and possibly arbitrators being removed, or things coming out after the event. I was involved in a very large arbitration in the Philippines. It took almost 3 years before we got to the hearing and got an award. And upon the award coming out, it became clear that one of the arbitrators was actually on the committee of a bank that stood to benefit from a party that had been given quite a large award. I think that was about 10 years ago, and they've still not decided what to do over it. So, uncertainty is a problem again, and it's something that we need to look out for. Expanded arbitrator immunity is very close to a lot of arbitrators' hearts here in Thailand in particular. We've all seen examples of arbitrators having been sued here. Under the UK Arbitration Act, the arbitrators are now protected from liability for a reasonable resignation and also from cost of orders unless they're acting in bad faith. So obviously the issue of the usual issues in terms of rights to set aside award are still there, but if the arbitrators acted in good faith, then they get a qualified immunity essentially. And this is seen as a good thing because it's perceived that arbitrators will not want to sit in particular jurisdictions if they think that there's personal legal exposure. And obviously the best thing for any arbitration market is getting the best possible people available, and anything that encourages that is to be encouraged. Next, the UK Arbitration Act looked at summary dismissal powers. And it's now the case that tribunals can summarily dismiss claims or defences with no real prospect of success. This can be particularly important in terms of the fact that we do know that tactical arbitration can be a thing, and it tends to favour the parties with the deepest pockets. There were some comments made earlier about access to everybody, which I obviously agree with. But sometimes when we're talking about access to everybody, we forget about the fact that if everybody has access, you also need essentially some sort of penalty for people misusing that access. Now that may come in the form of a summary dismissal. But it should also, I believe, come with cost consequences. At the moment, it appears that it can be far too easy to start arbitration proceedings as a tactic in circumstances where you will eventually be able to produce a drop-hand settlement because the other side needs to do everything they can to get out and they can't afford the costs, which can really penalise some parties over others. But obviously part of that is allowing tribunals to dismiss claims early, which is, as I said, now been legislated for in the UK. Just three more. Empowered emergency arbitrators. So these now have the same powers as full tribunals in the UK, much more extensive than we see here, including peremptory orders and seeking court support. So obviously it's very important where you've got time-sensitive disputes, and it enhances the enforceability of interim relief, which is something that again is perhaps lacking in the Thai market, and something that we could really do with some legislative guidance on. Equally, there's now streamlined jurisdictional challenges. So it limits full rehearings in court and reduces the delays and costs. I think it's also good, just generally as a thing that improves efficiency around the whole issue of arbitration, which is something that we all want to do. One thing that it brings to mind for me is issues that we have here a lot are relating to essentially rehearing cases where it should be really an enforcement matter, and that should probably be a delaying factor as well. And it also brings in matters of evidence, which again in Thailand we feel like it's really not concentrated on enough as the legislation sort of stands. And then finally the point here, that was kind of what I started with, which is they're looking to reinforce London's global role under the UK Arbitration Act. That's something we'd really like to see Thailand do, is put some legislation forward that really tries to encourage arbitration in Thailand and take away some of the things that are seen as uncertain, so that we can really move on with encouraging people to come to Thailand and taking advantage of all the great people in this group.
I think personally, a lot of these points, the key reforms under the UK Arbitration Act can resonate or actually happen in Thailand. A lot of the provisions under the Thai Arbitration Act are provided perhaps a matter of improving or modernizing our laws to be more arbitration friendly and topics such as if you are safe to see, Chantinara or Gurat Ambulance, anything on this particular point.
Thank you, Pai. I think one thing to add, like Ian mentioned, we can look to the example in UK reform. I would like to raise one thing that Thailand to be the safe place for arbitration. Arbitration, like, kind of related to people, and the most important people is our arbitrator. So in Thailand, I got a lot of experience in some cases that the losing party try to sue arbitrator. I mean, for arbitrator to liable for their personal liable, I think something like I just mentioned that they should have some protection in terms of some protection of liability or something, so we can like attack to like the good people, good lawyer, good arbitrator to come to Thailand, and then we can promote more to be the safety to have some protection. I'm sure that there will be some exception about like bribery or something, but it should not be like pattern or tactic for losing party try to litigate the case by filing a lawsuit against the arbitrator. This is kind of the example that we can improve Thailand to be a more safe place for arbitration, like intervention compared to UK.
Maybe I should add a little bit regarding the law governing arbitration agreement. I think maybe Thailand should consider the position that adopted in the UK Act. Yeah, because like right now we don't have a clear rule yet under the Thai law. Although I have come across one of the survey by Professor Edwin Mary, I know her, so I don't want to mention the name. That in the map of the research they highlight the Thai the map of the Thai country as a blue color, which is mean that we use the law of the sea. But if you look at the Thai Act and if you look at the Thai court decision, I don't think we have that qualified answer yet, so that might be a little bit slightly misrepresenting. But yeah, I think that is a good thing to start with, because this day people say that after the N9 decision, people say that this day if you are arbitration key, might have to specify 3 types of law company for each type of situation.
Clients don't like that. They pay the lawyer 3 times to draft the same contract.
Yeah, exactly. So that just maybe one point that I like to add.
Thank you very much for sharing that. And I think we'll touch or we'll discuss more about Thailand later on. And yet we were going to share about how the insurance space and the arbitration with each of these.
Yeah,
thank you very much.
It's an area, and it's also an area that I'm very familiar with in terms of discussing with clients how arbitration takes place in Thailand in relation to insurance disputes. By chance, I had an email from the client on Monday of this week on this very issue, and so it's very close to their hearts. And again, it comes back to the sort of uncertainty issue. So what I've said here in the slide here is that we need to be able to see arbitration insurance is what I'm mainly going to talk about, which is business to business. We all understand. We all understand that it's important for policies in Thailand to be subject to Thai law. And that's pretty consistent with most jurisdictions. Most policies have to be subject to the law in which the country in which they're based. I also understand that it's normal to expect that there will be specialist tribunal rules and rules for consumers. That's very consistent. Most countries will have some level of legislation and consumer protection, because consumers typically are the small guy there, the David versus the Goliath, in terms of the relationship between them and their insurance. But what it means is if you apply this across the board, there's an inability for businesses to contract out arbitration with chosen specialists as arbitrators, which is what you'd be allowed to do in other countries. You'd say, well, rather than go through the law or through whatever regulatory body, we're going to go through arbitration. We're going to be able to choose 1 to 3 experts in the field that can really understand the issues in dispute. And it's just frankly not attractive when they don't have that ability. And if I give some examples, purely off the top of my head, not suggesting anything, if, for example, you have PTT in a dispute with AIG, should that be in front of a regulatory panel with a pre-chosen arbitrator who will have some level of experience but maybe not have dealt with the kind of complex disputes and the high amounts in this particular case? Now we look at the Office of Insurance Commission. They have very much what I would call a consumer type focus. The procedure is suited to consumers. It's relatively low cost, which is not to say completely low cost, and it's relatively quick. They use institutional arbitrators put forward by the OIC, so it's very much what I would call protectionist, aimed at consumers, which for the consumer seems, I would say, quite reasonable. But then you look at the perception outside Thailand in terms of certain insurers. They look at the lack of arbitrators with what they perceive as the necessary expertise, and they think that's a problem. It creates uncertainty. They look at it in terms of a regulatory body as being a sort of public policy of some civil servants looking more at protectionism of consumers and not necessarily at getting to the right result. Now, whether that's correct or not is not the point, it's how they perceive it when it's a regulatory body with not so much ability to be independent in terms of choosing via the parties. And so that is an issue purely in terms of insurance arbitration. Now you look at the Thai insurance structure and it's diametrically opposed to what you need. And what I mean by that is typically in terms of large policies, you're looking at companies that could potentially have losses running to hundreds of millions. And Thai insurance companies don't have the capital adequacy, they cannot afford those losses. So what they do, because under the law it has to be a Thai insurer, they insure on what's called a fronting basis. They take maybe 0.5% of the risk, and 99.5% is reinsured out of the country into Singapore. And the issue is if you're asking reinsurers from outside of Thailand to reinsure on a basis that they have less confidence in the potential outcome of a dispute if it goes before the OIC compared to normal international arbitration, some of them withdraw from the market, and we all know what that means. If they're not coming into the market, less supply means higher prices. Higher prices means Thailand becomes less attractive in terms of investment. And then, of course, there's the aspects in relation to the complexity of disputes. You can be talking about a myriad of different types of technical things that happen in Thailand, where you're talking about concepts that have been around for hundreds of years in common law and are adopted under Thai law, but not necessarily adopted in quite the same way. And so you need expertise where people understand the differences between Thai law, and I've used the example here of utmost good faith compared to other places. But at the same time, you want people who can be on a panel who understand the complexity of the insurance market and what the purposes of these things are. And then finally, in terms of, I mentioned high value, as I said, if you're talking about something that can happen in Thailand, taking examples we've seen over the last few years, whether it's a pandemic, whether it's an oil spill, an explosion that leads to an evacuation over a large area, These are all things that have incredibly high value, and so the companies that are insuring that will want some certainty before they enter the market. Underwriters and insurers are based on one word, and that word is risk. They try to mitigate risk as much as possible, but the more they have uncertainty, the more they can't mitigate that risk. And so this is an area where I do believe that we need to sort of get talking about business-to-business arbitration being outside of the regulatory environment, more in the kind of international arbitration environment that we're all familiar with.
Thank you very much. Thank you very much. That's very comprehensive, and I think it showed a lot about insurance arbitration, and I think perhaps even the opportunities that THAC in jump in and provide expertise in resolving disputes between B2Bs. I'll just move on next to Khun Warathon, who will be focusing on Thailand's current position in regards to court roles, which are very, very important, and how this affects and attractability and acceptance of Thailand as an arbitration seat. Khun Warathon will have some slides to show us, so please bear with us.
Thank you. I think I will discuss about overall our main theme is about to Thailand to be the safe seat arbitration. So to be that in that position is very important because as everyone in this room know that arbitration is about the concept between the party, but actually the arbitrator don't have any official power or can enforcement anything. We need the hands, the helping hands from the mechanism of the legal mechanism in Thailand to help. So today I will discuss about the court as a hand to support arbitration in Thailand. We have two big topics. The first one, the court to support toward arbitration. So under Thai Arbitration Act, they have some provision that arbitration will need some help from the competent court. And the second issue will be like in Thailand, we discuss about if we would like to improve our position in like arbitration market, should we have the specialized court to responsible for all arbitration case. So we will discuss later. So we will go first thing first, like the court and the hands who help to support arbitration. To summary for at least for my experience, but after this topic I will ask our panelists to share any other issue for the court to support. I think at least for me to speak 4 issues. The first one, the court will get involved in terms of like to decide about jurisdiction, at least under Thai arbitration. Even though like we know that like arbitrator can rule on their jurisdiction, but under Thai law they have one provision under Thai Arbitration Act mentioned clearly that like we can submit petition to the court and the court will be the final say on jurisdiction. The second thing I will discuss about injunction. As you may aware in this room that like somehow parties cannot wait until the end or the final judgment because along the way might have some increasing damages. So somehow the party might try to seek an injunction. But in Thailand, arbitrator, even though they have some rules that say that arbitrator can issue injunction, but when we enforce injunction, we will discuss on how come we can enforce injunction order. The third will be document production. In Thailand, we don't have what we call discovery process. So we will not in the litigation, normal litigation, we will ask the court to subpoena some documentation or try to call the witness come to the court. This kind of thing we mentioned in Arbitration Act. And the last one, the most important, the court ruling about the award because of otherwise it's useless. It's just a paper. Award is just a paper if we cannot enforce the award. So we start with the first issue about jurisdiction. In Thailand, under Section 74, Paragraph 3 of Thai Arbitration Act mentioned state clearly that the tribunal have the power to determine the jurisdiction issue. But if the tribunal render the order based on the jurisdiction, the party still have the right to go to the competent court in Thailand to ask the court to rule on or challenge on the jurisdiction. So it impacts us. I think it depends on two scenarios. The first scenario would be the tribunal, the party try to challenge the jurisdiction, and the tribunal wait until the end of the hearing, try to render or issue in the award. It means the tribunal will render the jurisdiction issue. So that might be difficult. That might be you need to wait until you challenge the award. But if you can ask the tribunal to determine the jurisdiction issue first, and then if the jurisdiction say that like the tribunal arbitration have the jurisdiction over this particular arbitration. In Thailand, we have the court to support. You can come to the court under section 24, paragraph 3 to challenge. We have some. We don't have much many cases, but at least I heard about like, there are some cases at the administrative court ruling about jurisdiction. And the most important issue would be related to the jurisdiction between THAC and ADR. So the court need to rule like whether which institution have like jurisdiction over that. This is one issue that like, the first thing about like, the court had to give some hand to make decision, final decision about the jurisdiction. The second issue I would like to discuss a bit on the interim injunction. Under Thai procedural code, we have like the section that we can go to the court ask for interim injunction. Under Arbitration Act, the arbitrator don't have the legal power to enforce the interim injunction. I saw some institution, THAC, TI amend the rule to say that arbitrator can issue the interim injunction order by the tribunal. But when it comes to the enforcement, it will be a little bit difficult because under Thai Arbitration Act clearly mentioned that the party need to go to the court to ask for the interim injunction for the arbitration proceeding. So I think if you would like to improve a bit for arbitration in Thailand, we might need to amend this section to mention clearly that after like, the tribunal issue the interim injunction order, then the court can enforce, or there should be some mechanism to enforce interim injunction order from the tribunal. But now you need to go to the court and ask the court to issue an interim injunction. And I would say that with due respect to the court, especially in some other courts, not in like central court in Thailand, the judges might not familiar with Thai Arbitration Act. When we go to, for example, in Eastern province, like we try to ask for interim injunction, section 16, the court asked me like, how come you come to this court without any complaint? Because of the court, when you ask interim injunction in litigation, you need to file complaint first, and then you ask for interim injunction, file a petition for interim injunction. But under the Thai Arbitration Act, you just file a petition for interim injunction, and the court asked me, where is your complaint? I said that no, it's just like arbitration clause and section 16 of Thai Arbitration Act. We can ask the court to render interim injunction. This is an example. Normally, when I got some experiences on the case about, for example, construction. The construction, when the contractor get award for the construction agreement, you need to pay the BTs, bank guarantees. And normally, like they will have some always have some dispute. 99% in all construction projects that like the owner will say that like project delay. The contractor say that because of like owner not contractor, but owner try to enforce the BG, and if the owner can enforce the BG, it means the contractor might be losing party. Then, so we need to come to the court, even though it's arbitration, but we need to come to the court to ask the court to issue injunction to prohibit the owner to call the bond. That's the one example. Next, the issue about like the court to subpoena and help arbitration. In arbitration in Thailand, we don't have discovery at all. So if we would like to have some internal email of opposing party, we don't have any mechanism to do so. can have like engage like expert, have some investigator to do that. Otherwise, you need to go to the court, ask the court to subpoena some documentation and evidence.
Let's just jump on section 33. Actually, I'm curious to ask you actually, do you normally rely or file application under section 33? Because in my experience working in international arbitration, there's always or almost all the time disclosure process or discovery. So what about your experience?
For me, if you are running the real international arbitration, then there will be some like TOR to agree on disclose some documentation. That's quite separate. But if you run like domestic arbitration in Thailand, like for THAC, TI, and both are Thai party, no way for discovery process like international arbitration. This is another thing that Long Hai mentioned that we should improve this kind of thing because you go to the court, it takes some time. Actually, in international arbitration practice, you have discovery and disclosure might be easier.
And why first influences by the territory?
Yeah.
Thank you. Sorry.
Yeah. And I think the last big issue on the court to support arbitration is about the award. Because of like if you running the arbitration and then you cannot enforce the award, it means useless. So in Thailand we have three issues: recognition, enforce the award, setting aside award, refusal to enforce the award. I can wrap up like, in just a few minutes. This is like the static on the cases that related to enforce the award and also set aside the award. If you can see the number, this number did not come from me. Thank you THAC. Just ask the junior lawyer to do the research by pick some information. If you can see like the number of like arbitration cases in Thailand, just like in total about like 60 cases, 80 cases, it's not much compared to like in Singapore. So we are like still a bit further away from Singapore or even like in the UK. And another key thing I would like to discuss that like in Thailand for the court that related to arbitration, not only the civil court or IPIT court, but from the number you can see that like the administrative court also get involved. The friend and colleague from other jurisdiction might be have some doubt how come administrative court come related to like the arbitration, because in Thailand in the past most of the concession will put arbitration court before the government losing the case and then they prohibit. But in the past, so a lot of cases related to like the administrative court, for example, like all mobile phone operators before the licensing regime. But in the past, we have all dispute for the concession regime, and then related to like, and then after you finish the TI or THAC arbitration, you not go to like IPIT court, but you go to administrative court. So we need also to make that the administrative court to understand the proceeding related to like arbitration as well. This is the timeline for enforcement. I think compared for us to at least for Singapore, if you got the award, you can enforce easily within like 3 months, 6 months. But compare, this is like slide just to show you how to enforce the award in Thailand. It takes some time. At least for the court of first instance, you might take 1 year or 1.5 years for enforcement of the award. And then if you like appeal, then you take appeal to the Supreme Court, take that 2 or 3 years. So it's quite a bit longer process compared to other jurisdiction. This kind of like section related to like setting aside. If you can see from the scheme, Thailand quite have a broad wording on setting aside award. It means especially related to public policy, and we can give some example about like misapplication of law can be. I mean, it's able to consider as public policy. This very broad because of in other jurisdiction when you as arbiter apply some law, it means your decision. But in some Thai court precedent mentioned that misapplication of law is deemed that like related to public policy. It's quite dangerous like compared to other jurisdiction. This kind of also this is like the authority of arbitration. They have some example that the court might review the merit. If the court quite strict on the merit and interpret the public policy issue with quite broader than it dangerous because of like normally people choose arbitration because they would like to avoid the court and they would like to have some expert to determine the issue, but the court review specifically in detail that not like meet with like real intention of the party. Then I pause here but to ask our analysts to share some their
I
thoughts.
think briefly before we turn to a more controversial topic.
I was just going to mention briefly in relation to bank guarantees and construction. I know exactly what you mean. We had an issue where we tried to take an injunction and didn't get it, and then the bank paid the guarantee back to the contractor. I was so furious that I actually wrote an article called Thai Bank Guarantees Not Worth the Paper They're Written On.
That might be the case that we're working on potentially. Yes, that's a question.
Question. Did you get the interim relief in Yes, when you applied for the relief, did you get it?
I would say 50-50, 50%. But nowadays, the question is about whether after we apply for interim injunction, whether you can get order from the court. From my experience, in the past 50%, but this year I think less than 50 now. It's very difficult. When you apply interim injunction to the court, actually normally we will submit based on emergency basis. It means that you need to show to the court that you have the real case, and if the court not against interim injunction, will be like serious damages. So answer your question, very difficult, not easy.
Thank you.
So I think we're going to touch on whether it's worth considering the very least a court division of the Thai courts to adjudicate matters related to arbitration specifically. For example, there are courts in many jurisdictions that have a specific or dedicated court or with judges that are educated or even practice arbitration before. That way, you may increase certainty and being a more safer seat for arbitration.
Yes, the current status quo for us about Section 9 of Thai Arbitration Act. If you can see on the screen, Section 9. Normally, the lawyer might be aware that like IT court, Central Intellectual Property and Internal Court will be the court focused on arbitration. We can say that, but actually Section 9 not just mention IT court, but in reality mention several courts. For example, a court where the arbitral proceeding conduct, a court in which each third party is domiciled, a court which has jurisdiction over the dispute submission to arbitration. So a lot of options. So if you have arbitration, it's not mean you go to IPAT and you can ask for interim injunction, or you can enforce award at IT court only. It does not work that way. So I try to make it more simple. This kind of some competent court under Section 9. The first one, IPAT court that we not familiar with. Second, the court where the arbitration proceedings are conducted. Normally, if we went for arbitration in TI, the civil court will be cover that. But now for THAC, located in Jawatanat, arbitration court. Not sure whether it will be
not sure.
civil court or the Minburi court. Not sure because it's quite a little bit further away. And also the third one, the court of the party domicile. So it depends. Like if your business office is located in southern Bangkok court, you go that particular court. So another thing, another court would be the court which is jurisdiction over the dispute. And also, as I mentioned, if you work on arbitration, not international arbitration, but domestic arbitration related to like the construction, the concession and related to administrative contacts, you need to go to the court the administrative court, and the percentage. Get back to Kevin, the percentage of getting injunction from administrative court now very low. I used to get the interim order just 2 times. So very low chance for administrative court now. Next, the key issue on this, because of the section are quite broad, and they have some precedent mentioned that it's not just only IT court or just one court, but actually they have some option so the party can choose. The difficulty would be like this. I have one experience, for example. One time, we will be the one, the party who apply for interim injunction. That one quite easy, you can shop it. But when you represent the party defending the case, and we know that for example, we are the owner, we know that the opposite party, the contractor will try to ask interim injunction. We need to guess which court they will go. And we will need to send all junior lawyer to go to the court in almost every court. Wait until the opposite party file an emergency application, and then we can attend the hearing suddenly. That's very difficult because in Thailand a lot of costs. So if you are the one who apply interim injunction, you can shoot. But if we are defending them, we no way to make sure that they will come to the court at all.
And also just to add, there's no centralized system where you can actually check the status of the cases. For example, you apply for injunction in THAC, and at the same day, technically you can also apply to the civil court, assuming the civil court has jurisdiction as well. So it's a very difficult thing for practitioners to follow.
Yes, and also I would like to mention one thing about IPIT court. When I was a junior lawyer, I understand that all arbitration enforcement of the award can go to IPIT court. Because Section 9 mentioned IPIT court will be the court under Arbitration Act. And actually they have some precedent and the ruling regulation under the IPIT court. IPIT court regulation mentioned that only the arbitration case related to intellectual property and international case can enforced by IPIT court. So like 10 years ago, like they have several cases that IPIT court refused to accept the case because of the jurisdiction. So I think this is a key issue. Another one key issue that we can improve a bit to be a more specialized court to help and support arbitration. And over to Ian and Kun Adarthi Japan.
Okay, so I just like to add a few points here. Actually, everything you have to take a look at the act establishing this court as well. For example, the case of the IPIT court, you take a look at the section 7 of the act establishing the court, the IPIT, and you will see that it's just only certain type of the subject matters that will be within the jurisdiction of the IPIT court. For example, there was a Supreme Court decision as well regarding the insurance dispute, which say that if it's domestic one, actually it's not within the jurisdiction of the IPIT court. It has to be the international one, for instance. And also, even for the case of the Supreme Administrative Court, from my experience, I have come across an order of the Supreme Administrative Court in the year 2013 with regard to the waterfowl case. It said that in that case, although it seemed to be the case against the Thai government, however, it's based on the treaty or the treaty-based arbitration. And in that case, the court ordered, in that case, saying that it's not within the jurisdiction of the Thai Supreme Administrative Court. It's a different one. It's not like the case where the claim arising out of the contract, because in the waterfowl case, if you remember, it's not the party to the concession, but it's the shareholder, which only have like 9.8% of the share. So you can't take for granted, have to double check for your client as well. And last but not least, I also come across as well, many of us might be familiar with the SIAC, Singapore International Arbitration Center, and found that the model clause even suggests the option to designate the SICC, Singapore International Commercial Court, to be the supervisory court as well. In that case, it might going to be even clearer for the parties if they adopt that. So I think last month, the Judiciary Office interviewed many of the experts in Thailand, arbitration lawyer experts, about the idea, the reform proposal, and I think most of it will address those section that Kun Warathon already mentioned, the section 15, and another one is actually section 9 as well. So we kind of have a majority opinion that we should have the specific institution of the court or not to make it, clearer for the parties in arbitration. Thank you.
Thank you very much, Takila. That brings nicely to the next topic that we, in the interest of time, will allow you to present on your part, which is relating to the legal framework governing investor-state arbitration in Thailand and the recent trends in this space. So actually, as these legal mechanisms involving investor-state treaties, international agreements, one may actually say that are often overlooked, but are actually very critical in expanding our businesses, increasing trade, and inviting overseas companies to invest in Thailand. So that's first this year. There will be a slide, please.
Very technical issue on the time limit, so I might selectively address something. Before I go to the context of investor-state arbitration, given that our topic of the panel is what does a safe seat for arbitration mean for the rule of law in attracting investment and increasing international trade, I'd like to start with what are they, the most preferred seat first. So according to the Queen Mary survey 2021, this is the preferred seat that answered by the survey respondents. So you see that in 2021, London and Singapore ranked together at 54% as the most preferred seat. And if you look at the Asia Pacific, SIAC also ranked third as well. However, in 2025, just to show you some competitive atmosphere to make you all, awake after the lunch break. So in 2025, the Queen Mary survey, the same survey is reported again. However, in this year, London is ranked first, and now Singapore and Hong Kong together ranked second at 31%. And in the region of the Asia Pacific, wow, this year, 2021, Hong Kong ranked first at the most preferred seat of arbitration. So maybe we should learn from this jurisdiction as well if Thailand want to be maybe hotter seat of arbitration in the future. Usually this country, they have a high reputation of rule of law. In particular, we also touch on with our topic of this panel as well. And if we look at this survey again, but this one is from the 2021, you can see that the question here is what adaptation would make the seats more attractive to the user. So the first one is that greater support for arbitration by local court and judiciary. So this one is one of the factors that is important as well, and increased neutrality and impartiality of the local legal system, and better track record in enforcing of the award, basically. Ability to enforce the decision of emergency arbitrator or interim measure. We touch on with our section 16 as well. Right now, we not even have a clear explicit provision in the act yet whether the tribunal have the power to, the tribunal itself have the power to issue the interim order, and could lead to different kind of interpretation. But in this survey, they already favor having emergency arbitrator already. So that is part of the item that we still looking forward to see the reform of the new of the current Arbitration Act, if we're going to have the emergency arbitrator provision or not. Although some people might argue that currently of the current version of Section 16, the Thai court more or less might act as an emergency arbitrator, but as Kun Warathon smartly address it, the procedure might be different though, right? Still some barriers there. So if we want to be a safe seat or be more attractive, maybe we have to consider all these survey respondents as well. So now let's come to the issue of investor-state arbitration, or when the other party is kind of government agency. Given the time limit, I will just cover a certain point only, not everything in detail though. So if we want to start with, I would have to start with definitely Section 15 of the Arbitration Act of Thailand. Of course, Thailand, took a look at the model law, but I wouldn't say that we are 100% model law country. For example, this section is not appear in the model law either. Just for the qualification, so the drafter at that time decided that we should include section 50 in our law as well, which state that in a contract between a government agency and private party, whether administrative contract or not, the parties thereto may agree to settle their disputes by arbitration. The parties to the contract shall be bound by such arbitration agreement. So basically, it's a green light for the government agency to include the arbitration agreement. So it's going to be kind of facilitated by this act as well. But it's still option, but you can put it. It's not like nothing to do with the administrative or not. So this is the position of the Arbitration Act of Thailand. However, as many Thai lawyers might have been well aware of this, you have to read. As a foreigner, you might not know that you can't just go straight to read the Thai Arbitration Act section 15 and then you conclude that we can insert arbitration clause. I think that might not provide you with a complete picture. You have to check the cabinet resolution as well. We have several of these. This is some example only. There are more than this. But for example, in response to a few high-profile arbitration award against the government, the cabinet have adopted a highly restrictive policy. Restrictive in this case means that in general, as a general rule, they're not really encourage the government agency to insert or agree to use arbitration in the government contract. Unless, but they still have some kind of case-by-case basis approval as well if they want to or need to, to include it. So these are the January 2004 resolutions, especially permitting the inclusion of arbitration clause in all concession agreements. That one is actually following arbitration case, the Thai government lost, the ETA case, and then the second one, even worse. This was later expanded by the July 2009 resolution, which prohibited arbitration clauses in all public sector contracts. So this comes all before just concession, and this one is mainly as a result of the waterbound case as well, unless the cabinet again granted a case-by-case approval. So after this cabinet resolution, by default, you're not supposed to put the arbitration clause in all government contract. Of course, lead to a lot of criticism, and then the cabinet adopt a more relaxing approach. Actually, also lead by the approach that initiated or led by the Ministry of Justice as well. And I put THAC there because THAC also play an active role in this, organize sort of meeting, brainstorming, and provide opinion to the cabinet as well. So the Ministry of Justice recognized that the restrictive policy was hindering the foreign investment and also damaging the country's reputation. So the Ministry proposed an amendment to the 2009 resolution. So now it reduced to only 3 types of the main contract of the type of the contract that will need the cabinet approval. So the first one mainly PPP. I might not go into detail because of the time. So the first one is mainly the PPP. The second one is the concession agreement, and the last one, the one that the government agency have to submit to the cabinet for approval in accordance with the royal decree on the submission of the matter to the cabinet 2005. So there are 3 main types only this day, according to the 2015 cabinet resolution. So that need the government approval. So in this case, they said that if there are problems or necessity, or if such a clause is requested by the other contracting party and may be unavoidable, the matter must be submitted to the cabinet for consideration and approved on a case-by-case basis. So, for example, there is a real example as well. The case where the ADB, Asian Development Bank, may request is under condition, otherwise, they're not going to conclude the deal with the Thai government if Thai government not allow the government agency to put or insert arbitration clause into the contract. So by default, these 3 types of the contract should not encourage to put it. But if there are some necessity or some problem or the other side request, can submit for cabinet approval. I heard that currently THAC is also working on encouraging the government agency, the relevant authority as well, to maybe consider the amendment to the template of the standard contractor to put the arbitration clause back into those standard contractor for the government agency as well. So we have to wait and see if it's going to be even more relaxing in the future.
Definitely a positive sign was actually the participants as well, the government agency, government officers here, and it shows that arbitration is starting to be in the considerations or in the mandate of these officers.
Yeah, exactly. Although we might have to accept as well that for some contract that have very small value and might not need the arbitration clause, that type of contract we might not need to put, but many times, especially those that is kind of the demand from the other party, the foreigners, sometimes we can't say no, otherwise they're not gonna have to deal with us. And in the past, a lot of complaints as well that this type of cabinet resolution gonna delay a lot, increase a lot of cumbersome and a lot of process on the government agency, and sometimes it's the loss of chance, business opportunity as well, because they have to go through several steps of approval. So we have to wait and see if it's gonna be even more relaxed in the future, but at least it's a positive side here. And so that is the first one about the arbitration clause. Can we include those clauses in the contract? And the last issue that I like to mention is about the exit membership, which is another popular issue as well. So basically, currently Thailand is the signatory but not yet ratifying the convention, as you can see. So we have a lot of debate whether or not Thailand should ratify the exit convention. Actually, a few months ago, we also had the exit workshop in Thailand, and I also speaker there. We discussed a lot of this as well. So the reason why some of the Thai authorities or even the government, they're quite concerned with the exit. I might not go through this, but you can see that currently, because we're not yet the full membership of the exit, so most of the award in Thailand, all of them basically foreign one or whatever, usually gonna have to be in line with the New York Convention, and under the New York Convention, Article 5, especially 5(2)(b), there is a public policy ground exception, so the court can invoke this ground as well if they found that the recognition or enforcement of the award would be contrary to the public policy. So you can see that a number of government cases as well that they lost in the arbitration, but the Thai court might later on, set aside the award based on this ground. So some government officers or even the cabinet member themselves, those politicians as well, they kind of want to rely on to keep the reliance on this one. And I like to know that for exit, actually exit have the exit additional facilities as well. But under exit additional facility rule for the enforcement one, gonna be under the New York Convention also. Only the full membership one, I use the simple term for normal people here. So only the full exit membership that you will be using the enforcement system of the exit. Another exit convention, there are only some limited ground there under Article 52. None of these include, and this system gonna be considered by the built-in committee, is the exit enrollment committee. So what is done there is that the Thai court have no room to say anything. I mean, further about the ground to set aside the award. So it has to be the system of the exit enrollment only, and none of those grounds under Article 52 incorporate the public policy at all. So only those grounds, and what is done, Article 54 said that it has to be enforced as if it were the final judgment of the court. So I think in the past they're quite scared of the exit full membership because as I said, many cases the Thai government lost in arbitration. Somehow the government have another opportunity, another chance in the court to revoke the Article 5(2)(b), the public policy exception. But if we enter full membership of the exit, then those grounds, especially the public policy exception, will be gone. However, I think many new generation of the government official and also the Thai court as well, they quite prefer the membership of the exit because I think I quite agree with them in a sense because if you concern with the public policy, actually I feel like the lawyers or the party, the team that representing Thailand in the fight in arbitration, they can still use those public policy related grounds, but in a different phase, with the jurisdictional defense phase of the host state. For example, you might try to find that the arbitral tribunal should decline the jurisdiction because there are some anti-corruption issues, bribery, for example. Some of the cases here in Thailand, we have the parallel investigation on that as well. Or even the case of Foreign Business Act, sometimes illegality of the investment. For example, the investment structure is not 49, 51 rule, those kind of stuff. Or even the investor haven't done the proper, the environmental impact assessment, those type of stuff. Although in reality, the tribunal, the arbitrator, they will consider in the line of the proportionality principle as well. If the breach is just a tribal, a small illegality, usually might not be proportionate to decline or the investment protection in that case. And sometimes there might be the issue of the hosted long-term tenants. For example, they never enforce those things at all. But when they have the case in arbitration, they try to invoke some illegality at that time. That might be too late, those type of things. But this is the case where even if we, under the exit convention, usually those public policy related matter can still be there at the jurisdictional phase. Depending on the lawyer, you have to work better than in the past. In the past, I don't think that they did well at this phase, and they rely on the court to apply the New York Convention Article 5 later on, which I don't think is a good idea. And and another thing is that even under the exit itself, currently there is a case of UK lockhopper versus Italy. I might not go into detail of the case, but in this case, even under exit, that because of the arbitrator appointed by lockhopper, the investor in that case, the UK one, he failed to disclose his prior criminal conviction in Italy. So I feel like he might not gonna be impartial in this case because given his hostile experience in Italy legal system, So, but he did not disclose that fact. So at the end, his undisclosed background created an objective appearance of bias against Italian state. And then, although Rockhaber won at the arbitration, but the award of the exit award had been annulled under the Article 52. 1A, which the tribunal have not been properly constituted in this case because of the failure to disclose this information. Another result, Rockhopper, the investor side, have to refile the investment dispute against Italy again, start again. So it just reported in September 27, 2025. And this is the detail of the case. So basically, even under the exit annulment grounds, not that impossible. And sometimes you can still relate it to the public policy matter as well, although indirectly, I would say.
Thank you much for that. That was I think if no one's familiar with the exit convention, its mechanisms and how it interact with investment laws and the concession agreements and representative agreements and arbitration, I think Ajahn covers everything there. So thank you very much. Considering time, we have a bit more, say 2 to 3 minutes. If anyone would like to ask any question or my very panelists, please raise your hand. Microphone around the room. Perfect.
Maybe I add one short point.
Sure, please.
So to sum up a bit, so actually for exit membership, the full membership to ratify legally, Thailand have to think about the outflow as well, because there are clearly a lot of direct investment. The investment outflow from Thailand, and clearly there are a number of cases already like Thai investor against Laos. Also in Egypt. I think the energy sector, and in Egypt one is very well known because in that case the Thai state-owned one have to file the treaty claim, but in the Cairo court, administrative court. Unlike the kind of the shareholder or the partners of this Thai entity that they can follow the case in the arbitration, because some treaty they say that either the court or the exit. And if we're not a member, then we have to use the certificate or the certificate, but in the court. So we have to think about the outflow as well. So overall, if we follow this, I think the rule of law of the state of Thailand would be great, incorporating all the suggestions from the UK model and also from other section of the Thai Arbitration
Thank
Act.
you very much. I don't say anything more. No, thank you very much. Our panelists, please everyone join me to give a round of applause.